you.
Hey, hello everybody. It is 12:01, so I'm going to go ahead and introduce our CLE presenter for today. My name is Jessica Miles. I'm an immigration attorney in El Paso, Texas, and I've been helping to coordinate this CLE series. This is the UNM School of Law Immigration CLE series, and it's put on in coordination by the Leifer Border Justice Institute. Today's CLE is called Getting People Out of Jail, and it's focused on how we can use habeas and work in the federal courts to try to get immigrants out of immigration detention. And our presenter today, I'm very excited about. Her name is Rebecca Sheff. She is a staff attorney with the Texas Rio Grande Legal Aid, which is based in El Paso. She represents low-income clients in civil rights, immigration, and domestic violence matters. She previously worked at Human Rights First and the Robert F. Kennedy Human Rights Center. She earned her BA at Macalester College and has her Juris Doctor from NYU School of Law. After law school, she clerked for the Honorable Roy W. McLeese III at the DC Court of Appeals. Rebecca has additional experience working internationally with human rights defenders on migration, non-discrimination, and civil space issues. Currently, she's working on a series of COVID-specific habeas cases, both in El Paso and down in the Rio Grande Valley. She's also working on other federal litigation matters regarding immigration and also does personal representation for immigration matters. After this CLE, I'm going to ask that you send your CLE certification to the email address on your certification, which is sgeorge2@unm.edu. So with that, Rebecca, would you tell us all about habeas?
Absolutely. Thank you, Jesse, and thanks to all the organizers for putting this on. Thanks to everyone for joining today. So as Jesse said, we're going to take about an hour together to talk about setting the people free, to talk about prolonged detention and habeas corpus. And right off the bat, I want to let everyone know I practice in Texas, not New Mexico. So I'm going to be talking today at a more generalized level about habeas, what you need to know, both as an immigration practitioner and as someone who may be practicing in federal court about habeas. But for a deeper dive into New Mexico habeas case law, that'll have to wait for another training. This is meant to be a broad overview. So today we'll be laying the table a bit, getting some background about what does it mean when we're talking about habeas. And then we're going to take something of a more focused look at prolonged detention habeas, which is increasingly relevant these days as people are spending longer and longer in detention. Cases are taking longer to go through. We're seeing now that case dates are getting postponed in immigration court due to COVID, among other things, even in detention. So we'll take a deeper dive into prolonged detention habeas. At the end, time permitting, we'll talk a bit about COVID-specific habeas cases, and I'll just wrap up with some closing thoughts to send you all on your way. Before we get into setting the table with this background, I just want to say too, this is meant to be a training for everybody. So whether you're coming from an immigration background, you know, your bread and butter is representing people on their merits in immigration court, great. Or if you're someone who's never touched immigration law and you may be more familiar with practicing in federal court, you know, this hearing is for people coming from both, or this training rather, is for people coming from both standpoints. So if you're an immigration practitioner, I would encourage you to think about today's training from the perspective of how can I issue spot and think strategically about when habeas might be a viable option for my client, whether it's me doing the habeas or me working hand in hand with the federal litigator who's doing the habeas. And we do that all the time in my practice. We routinely work with people who are represented on the merits by an immigration attorney, and we come in and work in partnership to do the habeas case. Or conversely, if immigration court scares you, you're like, those aren't even real judges, there's no rules, that sounds super sketch to me. I like typing, I like research, I like writing, I think I'd be great, you know, briefing in federal court, but I don't really want to be on the sides, you know, standing up arguing with me and immigration judges. Great, you know, habeas is for you. Like this is something that is, you know, not a sort of copy paste exercise, but habeas, you know, petitions tend to be relatively straightforward to put together. And I think you can learn pretty quickly with mentorship how to put together a simple habeas and then how to, you know, be prepared to handle more complex cases as they come your way. So peanut butter and jelly, immigration and habeas, you can do it. Think about the perspective you're coming from, but hopefully this is useful to you either way. So just to contextualize a little bit, what are we talking about? If you've come to the earlier trainings in this series, you've heard attorneys talking about what the situation is at the border, what it means to represent people on the merits in their immigration cases, where the government is an immigration court trying to get them deported and their attorney is representing them, trying to get them some benefit or relief from removal. We heard some talk in prior trainings about bond, about parole, these ways that you can engage with ICE and with the immigration judge to try to get people out of detention. Habeas kind of stacks on top of all of that. Habeas is what gets you before a real Article 3 judge in federal court to finally have a real court take a look at whether your client should remain detained, whether that is justified as a constitutional matter. So it's important to keep in mind the interplay between the merits, bond and parole, these other means for getting someone released, and when habeas is an appropriate option to consider pursuing. So please don't glaze over. We are going to be talking about some law. Stay with me. I wanted to kind of contextualize what we'll be talking about today in terms of the statutory authority that the government has to keep people in immigration detention. We're going to focus today on 235B, but I want to lay out for you these 4 different statutory authorities so you have a sense of where this fits in. Your own practice may have you focusing on 236C, on folks detained under other authorities. Because we're near the border, because we tend to see a lot of so-called arriving aliens, I'm going to focus on 235B. But just to run through these briefly. So there's 4, generally speaking, 4 statutory authorities for people to be held in immigration detention, which is civil detention. You have INA 236A. This is like the general detention statute. It's applicable for people who are apprehended in the interior of the US and are being put into removal proceedings. And then you have 236C, which is generally speaking for people who have certain criminal convictions who are then being taken into immigration custody once they complete their time in criminal custody. 236A, people who are subject to that general detention statute, they should be eligible for bond, which means they can go before an immigration judge and ask for bond to be set so they can be released from detention, or they can get conditional parole, which is granted by ICE. People in 236C, by contrast, who have this criminal conviction that makes them detainable under 236C, they're subject to what's called mandatory detention, which means that generally speaking, they can't be released on bond. The IJ has no authority to set bond for them. They're mandatorily detained. And then we have INA 235B, which is what we'll be focusing on today. These folks are also subject to mandatory detention. 235B is for so-called arriving aliens, and that's a term of art. That applies, generally speaking, to people who come to a port of entry. They come to the bridge at the border, and they say, I'd like to come in, please. And so these might be asylum seekers who don't have any papers, who are coming to the port of entry to start the process of requesting asylum, or they might be returning green card holders who are seeking admission. We're going to focus for our purposes today on asylum seekers coming to a port of entry seeking to start the process of proving their case and who are taken into detention. So if you come to the bridge at the border and you're not admissible, you will be processed, and if the government decides to detain you, you're subject to mandatory detention. This means, like the people in 236C detention, that an immigration judge does not have jurisdiction to do a bond hearing to set a bond for that person to be released. So for someone who is arriving at the border, at the port of entry, and is classified as an arriving alien, their only options are to either request parole with ICE, and that's a discretionary determination that ICE makes that's non-reviewable, or to do habeas. And we'll talk, that's exactly what we'll be focusing on today. We'll talk about the nuts and bolts of what habeas looks like for these folks. Because if ICE denies you parole, unless you do habeas, you're out of luck. You're going to be detained for the duration of your immigration proceedings. And then we'll be talking a bit today as well about the fourth category, the fourth statute under which people can be detained, which is 241. 241 applies to people who have final orders of removal. And this is final, you know, after appeal, after, you know, the full proceedings, you know, if you have a final of order of removal, you're classified under 241. And that includes people who have been granted some lesser protections like withholding of removal or Convention Against Torture protection. So, you know, this training is meant to be a broad overview. We're not going to get into the ins and outs of when someone goes from being classified under 235B to 241, but I want you to keep those distinctions in mind. 235B, you're still in proceedings, you're an arriving alien, you're subject to mandatory detention. 241, you've got a final order of removal, but you're still detained. So that's the big picture. For immigration attorneys, talking about issue spotting, rule of thumb, when do I know habeas should be something I'm thinking about? This is a shorthand. But generally speaking, if your client does not yet have a final order of removal, they're detained under 235B, meaning they're classified as an arriving alien, you should be thinking about habeas when they're coming up on about 10 months total of detention. That's about when the courts will start being willing to say that someone's been subject to prolonged detention. That depends on your jurisdiction, it depends on the case law that applies, but that's about when you want to start thinking about habeas as an option. Post-final order, on the other hand, if you have a client who has a final order of removal, they're still detained, maybe it's because they're having trouble getting travel documents, what have you, but they're classified under 241 with this final order. Once it's been 6 months, prolonged detention kicks in. That's a much more straightforward line that after 6 months, their continued detention is no longer presumptively reasonable. So those are your guardrails. You want to be thinking about 10 months pre-final order, 6 months post-final order. And that's when it's time to either look into habeas yourself or talk to someone who does habeas. All right, so we're talking about arriving aliens. We're focusing on 236B, like I said. And like I said, these are people who come to the border, who come to the ports of entry, seeking to come in. And so for asylum seekers, generally speaking, pre-COVID, more like normal times, someone would be brought into the US, detained, you know, probably given a credible fear interview, and if they pass that, put into immigration proceedings, so they're, you know, doing their merits before an immigration judge, and meanwhile they're detained. There's something here called the entry fiction that is important to know if that's not a familiar concept to you yet. So the entry fiction is an idea that's been elaborated through case law that if someone has presented at the border and they're not admissible, they're considered an arriving alien, the law treats them as if they're still at the border knocking on the door trying to get in. And even if they're taken into custody, even if they're physically detained in the US, they could be transferred around to different detention centers. They could be detained deep in the interior of the country. doesn't matter. The law still treats them as if they're subject to this entry fiction, meaning that they're still at the border knocking on the door. Why do we care? Why is this relevant? You know, this matters because it goes to what are their constitutional rights. We know that non-citizens in this setting are subject to, or enjoy rather, fewer constitutional protections than persons inside the United States. But the question is, what's that residual measure of constitutional rights that they benefit from? And so the general understanding has been that people have some due process rights, even when they're subject to the entry fiction, even when they're arriving aliens still knocking on the door of the US trying to come in. So what does that mean? It means that, for example, the US can't just torture them, can't just execute them. There's fundamental liberty-based due process protections that people still benefit from constitutionally, substantive due process protections, when they're detained as arriving aliens. But what procedural due process protections do they get? That's where the fight comes in for habeas. Because if the government had their way, you know, people would just be detained if they're arriving aliens subject to mandatory detention. They would just be detained until the end of their immigration proceedings, no matter how long that took. And we're coming in saying, no, you have to justify their continued detention once it's become prolonged. If it's prolonged detention, you can't just keep holding them. That starts to look more like indefinite detention. They have some procedural rights to have the government be compelled to come into court and justify why they're remaining detained. So the two cases I listed at the top here, NZM v. Wolf and Jalloh v. Pitts, these are cases that I worked on directly, where the court ultimately, the habeas court ultimately agreed with the bulk of case law as it stands currently, that arriving aliens have some due process right to have their detention reviewed once it's become prolonged. These decisions that have been percolating through district courts all over the country come in the wake of a Supreme Court case called Jennings v. Rodriguez from 2018 that's important to know about. Jennings basically kicked the constitutional question of whether someone is entitled to having their detention reviewed down to the 9th. The Supreme Court avoided it while ruling on some statutory questions about detention authority and protection against prolonged or indefinite detention. So in the wake of Jennings, while that case has gone back down to the 9th and it's, you know, going through further proceedings there, different district courts, including in our part of the country, have been considering grappling with this question of what's the measure of due process rights that arriving aliens should be afforded. So we've had some success in NZM, in Jalloh. These are, you know, in the Southern District of Texas, 2 different judges, 2 different divisions. We've gotten judges to agree on the merits in habeas proceedings that people do have due process rights to have their detention reviewed by way of habeas. Not all courts have gone this way. And this is where it's important to do your homework. You need to be researching where the case law is in your jurisdiction. And because this is a training for New Mexico attorneys, I wanted to highlight for you this recent case, Gonzalez-Aguilar v. Wolf. This is a case that was decided in the District of New Mexico just earlier this year, and it went the other way. It denied habeas to a trans asylum seeker from Honduras who was detained in New Mexico with her case up on a petition for review to the 10th Circuit. And this individual was represented by NIJC and ACLU New Mexico, and it went the wrong way. And I say this not to dump on those litigators, but to say that even when you have a powerful litigation team behind a case like this on habeas, you can still see judges splintering on the fundamental question of how much arriving aliens benefit from due process protections. So here the court said, this person's not subject to indefinite detention. Her detention will be over when she either wins or she gets deported. And so there's no problem here. Even, you know, never mind how long that process might take, we can see an end date, you know, further down the road over the horizon, one way or the other. She'll get relief or she'll get deported. So we don't think this is indefinite, so she doesn't get habeas. And the court went against what we consider to be the bulk of the case law, as we saw with our own cases in NZM and Jalloh, The court went against that in Gonzalez Aguilar and said, we don't think that case law and due process has evolved enough that we are compelled to find that she has procedural due process rights entitling her to this habeas review of her detention. So that's a setback. That is something that if you're filing habeas in New Mexico, you will have to grapple with. And, this is a practice community that's pretty tight. I would encourage you, if you're doing habeas, to reach out to litigation teams that have worked on recent cases, strategize, talk together, figure out how to distinguish your case. But it's important to know that you're starting from a difficult place now that we have this decision in Gonzalez Aguilar. All right, bear with me. A little bit more background in terms of the case law. This is a CLE. We're talking about some more technical stuff. There is another case that just came out of the Supreme Court this term in Thurisigium. And this case is important to know, kind of hanging out in the background. We're still seeing how much of an impact it will have in litigation for habeas for arriving aliens. This case dealt with the entry fiction. So that legal concept I was just talking about before, where someone's still considered to be knocking on the door of the United States trying to get in, if they're considered arriving aliens. Thurisigium wrestles with that question as well. For our purposes, I'm not going to address the full spectrum of what the court decided in Thurisigium. What we need to know here is what the court talked about in terms of the scope of due process rights afforded to individuals who are coming in to the United States at the border seeking asylum. So this case dealt with an individual who didn't come to the bridge, didn't go up to a CBP officer at the bridge and say, "Excuse me, I'd like asylum, please." This dealt with someone who entered Iwi, who entered between ports of entry unlawfully and was apprehended and sought asylum from that standpoint. The court here said, we don't care that he entered between bridges. We're still going to treat him as if he's subject to the entry fiction, just like we would for arriving aliens who came to the port of entry. So he is subject to the entry fiction, just like someone who came over the bridge and requested asylum. And then the court went on to say, for people in that posture, they don't get due process rights beyond what's been authorized by Congress. And this comes from an old case called Mezzi. This is something we wrestle with all the time in cases for arriving aliens. So Mezzi said, there is no additional measure of due process rights that people get constitutionally when they're arriving aliens. They just get the statutory rights that Congress has afforded them. For arriving aliens, what is that? That's parole. That's your ability to go to the ICE officer detaining you and say, "I'd really like parole, please let me out." And that's a discretionary decision by ICE. Mezzi said you don't get anything more than that. But the bulk of the case law, like I was just saying, is moving beyond that and saying, no, people do have a right when they've been subject to prolonged detention to compel the government to justify by clear and convincing evidence that their continued detention is necessary because they're a flight risk or a danger to the community. In Thurisigium, the Supreme Court reinforced and sort of re-upped its holding in Mezzi and said, nope, too bad, you only get the rights afforded to you by Congress. So I would expect when you're litigating habeas for arriving aliens, that courts will start to point to Thurisigium to say, we don't need to, just like they said in Gonzalez Aguilar, we don't need to have a habeas hearing on whether someone's prolonged detention remains justified. They'll be released at some point. We're not too worried about it. They only get the rights afforded to them by Congress through statute and regulation. So it's important to have all these pieces kind of laid out in your mind when you're getting into thinking about habeas. But most importantly, you need to know the case law in your own jurisdiction and do your homework to figure out what landscape it is that you're coming in on top of, trying to get a judge to order your client released through habeas. All right, that was setting the table. Thanks for bearing with me through all of that. We're now going to focus more on the nuts and bolts of prolonged detention habeas for people detained under 235B, who are characterized as arriving aliens. So timing, like I said, you want to be thinking about that rule of thumb. Has it been about 10 months of detention pre-final order, or post-final order if the person's characterized as 241, have they been detained 6 months? Those are sort of your triggers in terms of when it's prolonged. Getting into this, you want all the way through, like any good lawyer in any case, to be managing your client's expectations. Habeas cases can move very fast or they can move very slow. And they're layered on top of your parole requests, your merits proceedings. There's a lot of moving pieces that are interlocking here. So it can be hard to predict for a client which way things will go, but habeas is another shot at trying to get them released while their immigration cases are ongoing. So, prolonged detention, pre-final order. You want to be thinking about teeing up the case. And if you're already doing the immigration case, great. If you're not, if you're just a federal litigator, you want to be working hand in hand with the immigration attorney to get the information you need, get the documents you need, and get it all set up. So first, you're thinking about the authority for the detention, what we were just going through. If they're characterized as arriving aliens under 235B, that's your starting point. If they're 241 post-final order, that's your starting point. If there's ambiguity between those two, like the person's up on PFR, do some homework, talk to a mentor, figure out your arguments for whether they're 241 or 235B. Then you want to be thinking about a couple other things. What's the overall length of detention, right? Let's say someone's been detained for a year, pre-final order, so you're thinking about a habeas for them. You want to get into breaking it down. How much of the delay in their immigration case so far is attributable to the government? And conversely, how much of that delay is attributable to the client? So, if your client requested a continuance 5 times because they wanted to look for a lawyer, but they kept not really trying to find a lawyer and they kept asking for continuances, that's delay likely attributable to them. If the government took 4 months to give them a CFI and then took forever to set their first masters and took forever to give them their merits decision, and then they appealed up to the BIA, that's the type of delay attributable to the government. If hearings rather in their immigration proceedings got reset due to coronavirus quarantine, you can argue that's delay attributable to the government. So you want to kind of tally up how much of this is attributable to the government versus to the client. And the more that's attributable to the government, the more you have a strong prolonged detention habeas case. So think through that, do your homework on that, figure out how you'll explain why any delay attributable to the client was reasonable because it's part of what they need to be doing to pursue their relief from removal. And then there's some things that you want to have already done, or if not, get them done very quickly before you file your habeas. So parole requests. If someone's an arriving alien, they're subject to mandatory detention, their only other way to get released besides habeas is by requesting parole. So if they've already requested parole and been denied, great. From your perspective, setting up the habeas case, great. If that request was made 5 months ago and it's stale, maybe they have a new sponsor, maybe they have better sponsor documents, maybe they have better information about why they're not a flight risk or a danger, you want to re-up that parole request and do a new one that's as strong as you can make it, and give the government a bit of time to decide on that parole request while you're setting up your habeas case. And that's to show there's no exhaustion requirement for habeas, but it's to show the court, look, Your Honor, I've done everything I can to try to get my client out discretionarily. ICE has not, and so that's why we're here in court doing a habeas. And then there's another sort of variant on a parole request called a FREHAT request that's relevant for people who are at high risk for coronavirus. If that's a situation that is relevant for your client, you want to be sure that a FREHAT request was made as well. FREHAT requests can be made for anyone in detention, no matter what authority they're detained under, no matter whether they're mandatorily detained or not. So get those requests in, make sure you have, if they're available, make sure you have the client's identity documents, make sure you have sponsor information for the client. You'll need that for your habeas case as well as your parole request. If you are dealing with facts that raise a concern about flight risk or danger to the community, make sure you've done your homework and worked up your information that you'll put forward to the habeas court to address any potential flight risk or danger issues. So you want to have that all teed up and ready to go. Another wrinkle these days with coronavirus, you want to be able to explain to the judge in your habeas case what the plan is for your client to be safely released from detention when they are en route to their sponsor. So if the sponsor is nearby, great, they'll just get picked up in a private vehicle, driven there, pretty straightforward. If the sponsor's all the way across the country, you probably want to identify either a shelter nearby that can house them for 14 days or until they're cleared through testing, or some other quarantine option for them. Maybe it's a hotel, maybe it's a private home, but figure out how you'll explain concretely, practically to the judge what the plan is to get them released and have them, be traveling to their sponsor in a way and with a timing that is sensitive to the public health concerns that exist around COVID. So what's the timeline? What are we really talking about here? So you've set up the case, you've done your homework, you've gotten the parole requests in, either I said no or you just got dead silence. And so you are getting into the actual habeas litigation. The first thing to do, of course, is to file the petition. There's a nominal filing fee, I believe it's $5. You'll want to have a conversation with the client about whether they prefer to file under pseudonym. If so, that's a little bit more briefing you have to do for your initial filing. And then with your petition, you'll be filing a motion for an order to show cause and a memo in support. And the memo in support is the bulk of your work in preparing your initial filings. That's where you spell out the why of why are we coming into court now, why habeas, why does my client qualify, why is this prolonged detention, and why should my client be released, because their continued detention is not justified constitutionally under either flight risk or danger to the community. So that's your initial filings. You get those together, you get your supporting documents, you put all that in, file it with the court, figure out what judge you have, and then the next step is to wait for the court to issue the order to show cause. In the order to show cause, the court can give the government up to 20 days to respond. So we always ask for the minimum, which is 3 days to respond. And we say, the government's got all the information they need. They already know about this person. They should be asked to, or compelled to respond in 3 days to the order to show cause. But the court can give them up to 20 days, no more than 20 days without an extension. So once that order is issued, then it's up to the government to respond. And that response is meant to give the government an opportunity to justify the person's continued detention by explaining why there's either flight risk or danger concerns that warrant their continued detention, even though it's become prolonged. Once they file their response, you get a reply. It's possible in these cases that they can get referred to a magistrate judge. It's possible that the court can decide these on the pleadings, or that the court will hold a hearing to talk through these issues. So when you're getting into habeas, you want to be assessing risk. You want to be communicating with your client about risk. This is just a laundry list of some of the issues that we've seen come up. If this makes your head spin, that's a good idea to talk to a mentor, talk to someone who has some experience doing habeas litigation so that you're ready to grapple with all of these. A lot of this is stuff that you'll address up front in your initial filings. So just to walk through this real briefly. So jurisdictional arguments. Sometimes we see the government come back and say, you know what, Your Honor, the petitioner is not really asking for habeas relief. They're asking for a redetermination of our parole decision. And that's discretionary, it's non-reviewable, and it's not properly before this court. And then we'll come back and say, no, we're actually making a due process claim. This really is habeas. We're not asking for parole to be redetermined, but you'll want to be anticipating that might be one way it goes. If there's some ambiguity between whether your client's detained under 235B versus 241, you want to be prepared to address that and to bolster your argument. Sometimes we get into custodian issues. Let's say someone's detained in a detention facility that's run privately by CoreCivic or GEO or what have you. we always have as respondents, not just the warden, not just the immediate custodian, but also people all the way up the chain in ICE, as well as UIR. And that's because ultimately, at the end of the day, the decision is not up to the guy in charge of the core civic operation of that facility. The decision is up to ICE and potentially UIR as well, which I'll get into in a minute. The government often comes back and fights us on custodian issues, saying everyone else should be dismissed. They're not proper respondents in this case. You should just have the immediate custody or the immediate custodian, who is the warden in this case. That's one fight you might end up having. And then you might get into challenges about the scope of due process rights for arriving aliens, like I was talking about before. The government will come back and say, well, under Mezi and Thurisigian, and if you're in New Mexico, Gonzalez Aguilar, you know, these folks, this petitioner, doesn't have due process rights to have their detention reviewed. They're subject to mandatory detention. All they get to do is ask for parole. And then we come back and we fight about where the weight of the case law is on that. You might get into arguments about how long the person's been detained or how much of that delay is attributable to the government. And that's where you want to know your case law. Your case law in your local jurisdiction may be very favorable. We don't have the luxury of picking what jurisdiction we're in. Venue for habeas has to be where the person's detained. So you don't get to be strategic about venue. If you were so lucky as to be doing a habeas case in a place like SDNY, they've recognized prolonged detention for lengths of time as short as like 7 or 8 months. In our experience in Texas, in the Western and Southern District of Texas, you've got to show a lot more. You know, we tend to find ourselves doing habeas for people who have been detained for like 2.5 years. Where that lies for you, how much you're pushing the envelope on the length of time that amounts to prolonged detention, is something that you want to know through doing your homework and looking at the case law in your jurisdiction. Then you can get into some other jurisdictional issues on the back end, depending on how things go. If your habeas case gets fully briefed up, you do the petition, the government gives their response, you get your reply. Sometimes the federal judge, instead of holding a hearing themselves on whether continued detention is justified, sometimes they'll kick it to an immigration judge. And sometimes that immigration judge will say, you know what, I don't have jurisdiction to do this. This is not a normal bond hearing. I don't have jurisdiction to do this. This person's subject to mandatory detention. That's another case where go talk to someone who's more experienced in habeas. If that's a practice you see locally, we tend to brief that up front to say in the alternative, you know, if you don't do the hearing yourself, if you kick it to an IJ, give them really specific orders about what needs to happen and have a backstop that if the IJ doesn't do the hearing in the way they should within, let's say, 2 weeks, then the person is ordered released. That's another nuance to keep an eye out for. And all of this, you're litigating it with the backdrop of a possible appeal, right? It's not generally typical to do a TRO on a habeas case. Habeas is supposed to move quickly enough that would be kind of redundant. But even if you win on the merits of a habeas case, the government might appeal it. And so you want to be thinking about the big picture of what your habeas case would look like on appeal and what the 10th or the 5th in our case might do with it. Because, you know, we often find ourselves in the 5th in the position of that even if you win, you lose because it goes up to the 5th and goes very badly. So these are just some of the risks, but some ones that we routinely run into. So given the limited time that we have, I'm not going to go into a ton of detail on these particular cases, but I did want to give you a snapshot of some of the cases I've worked on directly, the different ways that they've gone. So we have 3 cases here. They were all filed in Texas, and they all came out different ways. And you know, I hope it just gives you a sense at least of the different directions that habeas litigation can go. So in case 1, we have MD. MD was detained at the Port Isabel Detention Center, and we filed for habeas in the Southern District in Brownsville. We briefed this one all the way through the merits. The government also filed a motion to dismiss and made a lot of arguments about how, like, we were asking for parole redetermination instead of presenting a constitutional claim. This one ended up taking like 7 months to be fully briefed. And we had a fair bit of back and forth with the court and the government in this case. Ultimately, the federal court that was hearing this habeas case decided to kick the habeas hearing to an immigration judge. Like I was just saying, sometimes they can do that. In this particular instance, the immigration judge didn't flinch, held the hearing, didn't raise any jurisdictional issues, considered flight and danger, and set a bond. And so we were able to get that bond paid. We did get this person out of custody on habeas after all of that, on a bond that we thought was too high, but you know, it's Texas, we got it paid. And so after about 2.5 years of detention, this person was released and remains released while he is continuing to pursue his immigration relief. So that's one way it can go. And at the end of the day, once you get through all the habeas briefing, the IJ hearing looks more like a regular bond hearing, but it's part of the habeas case. And that's how he got out. In our second case, NZM, another individual who had been detained for about 2.5 years, he was held at the Rio Grande Detention Center in Laredo. We filed a habeas petition for him. Again, we went all the way through briefing it, petition, response, reply, all the way through. The court was taking some time to decide. We did a COVID TRO for him. That got denied, unfortunately. But then ultimately, as his immigration case proceeded and he got remanded back to the immigration judge for more proceedings, it was at that point we believe that it was clear to the federal judge that he really was going to be detained for a lot longer going forward if she didn't grant the habeas petition. And so at that point, she ordered him released. And she didn't kick it to an immigration judge. She just ordered his release directly on an unsecured bond of $5,000, which is great because it's no money down, and it amounted to his immediate release by order of the federal court. So that was very exciting. He also remains non-detained now as he continues to pursue his asylum case. And then our third case here, we have the case of OBV. He was also detained at Port Isabel. He was originally in MPP, the Migrant Protection Protocol, so he was stuck in Mexico, presenting his immigration case in the 10th Court in Brownsville. He won pro se, he won withholding, but the government appealed. And so he was taken into custody during the pendency of his BIA appeal. Now the government really screwed up in his case, in the BIA case. They represented to the BIA repeatedly that he was non-detained and went so far as to say he wouldn't be prejudiced by an extension that the government was asking for because he was non-detained. And so not only did they do that, but they also sent the notice of the motion for extension for BIA briefing to his proposed sponsor instead of serving him directly while he was in government custody, which caused him to miss BIA briefing deadlines. We got his case after he'd been detained for about 7 months, so way shorter than what we would usually consider for a habeas case. But because he had previously been an MPP, and because of the facts of what had transpired during his BIA case, we felt pretty confident that we could bring a habeas petition on his behalf. And sure enough, we filed it, and he was released by the government within 24 hours of us filing the petition, which moots out the habeas case and gets us what we want, which is getting him out of detention. That used to happen a lot more. The government's been litigating these cases to the hilt more recently, but sometimes you get facts like his that are particularly exceptional, and they will release people to make the habeas case go away. So that's just a bit of a snapshot on the different ways these cases can go. All right, that's prolonged detention. And like I said, find a mentor, find a partner, find someone to work with on these who knows how they go and has some knowledge about your local jurisdiction. Once you do 1 or 2 of these, it gets easier. It gets a lot easier. And then you can, focus on the nuances of what makes your case particularly complex or distinguishable from the existing case law. All right, we've got about 15 minutes left. So I'm going to talk a little bit about COVID-19 habeas cases. This is another one where we could spend a lot more time talking about this. I just want to give a bit of a snapshot of where these cases are these days and how to think about them. So early on in the pandemic, not that there was 100% success, but courts were pretty willing to order release in these types of cases. It's gotten harder to win these as time has gone on. I think there's some atmospherics there where courts are perhaps less fearful of the consequences for people detained, as we all have kind of become accustomed to living with the pandemic. That doesn't just diminish, of course, the very real harm that people face in detention who are exposed to COVID-19, but we're all sort of learning to live with it. And I think some of the fear factor for judges has kind of diminished. And also, as the pandemic has unfurled, ICE and the private detention companies that run facilities for ICE have had a chance to put in place more mitigating measures, to develop more protocols and guidance on how to handle COVID-19. And that gives them more to point to say, no, Judge, we're working on it. We're doing something on the COVID issues here. And, people are as protected as they can be. Depending on your judge, depending on your facts, some courts are less willing to consider COVID-19 habeas cases unless there's an outbreak already in the particular facility that your client is detained in. Some courts are more willing to consider granting a habeas if your client has particular vulnerability to COVID-19 due to either their age or their comorbidities. So all things to keep in mind. Criminal history, flight risk, and danger, also things to keep in mind like you would with any habeas. So COVID-19 habeas, you have some choices up front about how you structure the lawsuit. You can do these as habeas cases, or you can do them as conditions cases, or both. And I've pulled some examples here of pleadings in both directions. So if you're just doing it as a habeas case, let's say the person already has a ripe prolonged detention habeas claim. They've been detained for 10 months or so or more, delay attributable to the government, everything we were just talking about. Their prolonged detention habeas is something that you could file whether or not coronavirus is an issue for them. You can sort of enhance your prolonged detention habeas pleadings by pointing to coronavirus as something that aggravates the irreparable harm that your client is suffering. And so, the fact of their continued detention, once it's become prolonged and unconstitutional, is itself an irreparable harm. The case law is very clear on that. But you can sort of beef it up with coronavirus to say not only are they being detained, for additional time now post it becoming prolonged detention, but they are at risk or perhaps at high risk because of their comorbidities of coronavirus, and that enhances the irreparable harm that they are suffering and gives the judge more reason to grant the habeas. You can also do these as conditions claims. And here it depends on what your goals are, it depends on where the case law is, what your resources are. These are big, messy cases. They're pretty high risk, generally speaking, and you kind of want an army of lawyers on these, honestly. You want to have the capacity in your litigation team to grapple with some pretty hefty briefing if you're going after this as a conditions case. If you're doing that, you're looking still to the Fifth Amendment to due process issues. You're looking to two different types of conditions claims. One, that the government, the respondents, are acting with deliberate indifference to the harm that your client faces due to coronavirus. And two, that the conditions of their detention amount to punishment. And this is civil detention, it's not meant to be punishment, but with coronavirus now, the conditions amount to punishment. Those are the claims that you would make if you're doing it as a conditions case. More briefing, harder to win, pretty high risk, but good to know what your options are. And like I said, if you're really, regardless of whether you're doing this as just a habeas case or also a conditions case, you want to be thinking about irreparable harm and thinking, of course, about documenting your client's risk vis-a-vis coronavirus. So you have a lot of homework to do up front. You need a client declaration that gets into not just the facts you would need for a regular habeas, but also, everything about their pre-existing comorbidities for coronavirus, the conditions in which they're being detained, their perhaps lack of ability to do social distancing or necessary hygiene and sanitation. You want to get all of that into a client declaration. You want to get their medical records from the facility. Great if you can also get them from wherever the client was living before they were detained. Communications with ICE, if the person, for example, has requested to be housed in conditions that allow them to do better social distancing and that's been denied, requested more medical care and that's been denied, get all those communications as best you can. And then you need expert declarations. And so that's a fair bit of work to get. Ideally, you would have a physician assess your client remotely and assess their medical records to determine if the person is at high risk for coronavirus based on comorbidities. So a lot of homework, different and more than what you would generally need to do for a regular prolonged detention habeas case. That's more or less where I'm going to leave things. I want to leave a bit of time for questions if there are any. Like I said at the beginning, even though this is a fairly jurisprudence heavy or somewhat technical thing to be digging into, I hope that it's something you can keep in mind, whether you are more of an immigration practitioner or more of a federal litigator. It's important to think strategically about when habeas will become relevant for your client, if you're on the immigration side, and to be lining things up, think ahead, say, okay, my client's been detained for 9 months now. I don't think their merit's going to be set for a while, or they just lost merits. I don't think they'll get a briefing schedule at the BIA for a while. I'm going to start talking to a federal litigator about possible habeas. I'm going to start thinking about re-upping my parole request. Get it teed up as best you can. And if you are thinking yourself about doing habeas cases, great, very exciting, contact me. We're happy to share pleadings. We're happy to talk strategy. My experience is in Texas, but hopefully we can work together to build capacity to do more habeas all throughout the Southwest, where we know many arriving aliens are detained and seeking asylum. Some, basic, practical, common sense things. Get admitted to federal court if you can, and that way you're ready to be in position to do the habeas yourself. If that's not you, if that's not your jam, find someone who is, develop a bit of a partnership and get in position. Seek out expertise in monitoring. Talk to folks who have experience doing habeas in your jurisdiction. If you can't find folks there, look around. Like I said, even though we're in Texas, we're happy to talk about the mechanics of habeas and kind of the questions that you should be digging into as you think about it in your own jurisdiction. And keep an eye on the broader state of play. So like I was pointing to earlier in the presentation, there was this case called Jennings that got decided at the Supreme Court that kicked the constitutional question back down. So right now we have, constitutional habeas questions percolating through all the different circuits. At some point, that's going to go back up to the Supreme Court. Maybe they'll go back up on Jennings, maybe they'll go back up on something else. But you want to know kind of the broader equities, what the government's thinking about strategically for how it approaches these cases, how hard it litigates these cases, how willing it might be to moot your client out by releasing them. And, to be thinking about obviously what that means in the context of, what's in the best interest of your client, but also how much are you teeing yourself up to potentially make bad law, either at the district court level or on appeal, that could make it harder for everybody else to seek similar relief. Because of those risks, that's why I think it's really advisable to seek out expertise in monitoring. But it's good to know kind of the broader state of play. And I will say in one of the cases I talked about earlier, the MD case where they kicked it to an immigration judge that got our client released through bond, the government has appealed that case. That case is going up to the 5th. Briefing will happen in the fall. And so, it remains to be seen what ultimately happens with that case. But you may find yourself thinking you're starting out with a small case where you hope you'll just file it and your client will get released the next day because your government opposing party doesn't want to litigate your habeas. But that may not be how it plays out, and you may end up litigating in the 10th and grappling with some pretty fundamental issues that may result in case law that affects everybody else. So with that, I think I'll see if there's any questions, and thank you all again for coming to today's training.
Rebecca, this is Cheryl.
Mm-hmm.
Yeah, somebody asked if you would be willing to share your PowerPoint. I mean, can you email it or no? Or
Yes, I would be glad to. I will email it to you or whoever the best person is at the school. And I'm happy to also provide my email, my contact information.
Okay, great. Thank you.
Great. Were there any other questions? Looks like not. All right, well, thank you all so much. Thanks again to the organizers.
Thank you.
Thanks very much. That was a fantastic presentation. We hope that the people who are watching that we are able to build the kind of mentorship that you are suggesting, and we hope that this adds to our effort to try to provide some relief and some education about what is happening at our border and what we can do, and we really thank you for the valuable role you've played in that. I don't know if Patrick Lopez wanted to add his 2 cents before people leave, as he's going to be doing his best to organize our efforts of our volunteers.
Yes, so I'm going to place my email address in the chat. If you are interested in volunteering and or learning more about how you can get involved, please email me. Also, if you would like I will make sure to be the one to distribute the PowerPoint presentation to those of you who are interested in receiving that. And again, thank you. This was an excellent presentation. We're so excited about all of this, and just thank you all for attending.
Thank you all. Don't be afraid of the federal court. Come on in.
Thank you.
Have a good day.
Thanks, Rebecca. Great job.